Hey guys, welcome back to our Pearl Lemon YouTube channel. So in today's video, we're going to be discussing everything contracts. So first things first, what is a contract? So a contract can be described as a legally enforceable agreement between two or more parties that creates, defines, changes, or extinguishes a legal relationship. Contracts are essential for business transactions, personal relationships, and everyday life. They govern everything from our business transactions to our personal relationships, but understanding contracts can be very tricky. So today we're going to break down the do's and the don'ts of contract formation. So without further ado, let's get to it. Firstly, let's talk about the do's of contract formation. These are the things one should do to create a valid and enforceable contract. Number one, do clearly identify the parties. By this, you need to ensure that all the names and addresses of all parties involved in the contract are clearly stated. This will help avoid any confusion about who is responsible for what. Number two, do define the terms and conditions. By this, you need to clearly outline the subject matter of the contract, the obligation of each party, and any conditions that must be met for the contract to be fulfilled. This will help to prevent any disputes down the road. Number three, do consider using written form. While oral contracts can be legally binding, written contracts provide a much more stronger evidence of the terms and conditions agreed upon. This is especially important for complex or high-value contracts. Number four, do obtain consent from all parties. Here, you need to ensure that all parties involved in the contract have read, understood, and agreed to its terms before signing. This will ensure that everyone is on the same page. And number five, do include a signature block. This is a very important point because each party should sign and date the contract to demonstrate their agreement to its terms. This is the final step in creating a valid contract, and it's a very, very important step. So now that we've covered the do's, let's get to the don'ts of contract formation. So the don'ts are things one should avoid when creating a contract. Number one, don't make vague or ambiguous statements. The terms of a contract should be clear, specific, and easy to understand. Avoid using overly technical language or jargon. Number two, don't rely on oral agreements for complex transactions. Oral agreements can be difficult to enforce, especially in complex or high-value transactions. Always get everything in writing. Number three, don't leave essential terms open-ended. Here, you need to clearly define all terms and conditions, including delivery dates, payment terms, and dispute resolution procedures. This will help avoid any disagreements later. Number four, don't enter into contracts under duress or coercion. You need to make sure that all parties are entering into the contract voluntarily and without any pressure or threats. Remember, a contract signed under duress is not enforceable. Number five, don't sign contracts without reading and understanding them first. Here, you need to carefully review the contract to ensure that you understand all the terms and conditions and that you are comfortable around it. Also, Do not be afraid to ask questions if you are unsure about anything. And number 6, don't sign contracts that contain illegal or unethical provisions. This is an important point because a contract cannot be enforced if it violates the law or is contrary to public policy. Therefore, by following these do's and these don'ts, one can be ensured that their contracts are valid, enforceable, and protects one's interest. Remember, contracts are important legal documents, so it's always a good idea to consult with an attorney or a legal professional if you have any questions regarding this. Thanks for watching, guys, and if you found this video helpful, please give it a thumbs up and subscribe to our channel for more legal tips and advice. Till our next video. Bye.